we are going to discuss labor relations and collective bargaining. So how do we deal with unions and grievances? So we'll take a brief look at the history of American labor movement, the basic labor laws, including unfair labor practices, explain labor negotiations, including the union actions you can expect during the union campaign and elections, and what you can expect during actual bargaining sessions and how to handle grievances. So 4 sections: employee relations, managing those employee relations. Oh, look at that. I didn't change that. Sorry. Okay, so brief history of the American labor movement. Unions remain very influential in the United States. Almost, well, I say there about 14 million US workers belong to unions. That's about 11% of the total number of men and women working in America. Almost 36% of public sector workers belong to unions. Some private sector industries, such as utilities, like utilities are 22% are unionized, and transportation and warehousing are 19.6% unionized. Can still be hard to get jobs without joining a union. Unionization also varies widely by state, from a high of 23.8% in New York down to 2.6% in South Carolina. So don't assume that unions affect employers only negatively. For example, perhaps by professionalizing the staff or systematizing practices, heart attack mortality among patients in hospitals with unionized registered nurses was 5 to 9% lower than non-union hospitals. Often employers' labor relation policies evolve. Support for unions has always ebbed and flowed in America, and today pressures are building against unions. So why do workers organize? Experts have spent much time and money trying to figure out why workers unionize, and they've proposed many theories, yet there's no simple answer. So yes, pay is still important, but it's not just the money. Instead, the urge to unionize usually comes down to the belief on part of the workers that it's only through unity that they can get their share of the pie and also protect themselves from the arbitrary whims of management. The bottom line is that low morale, fear of job loss, and poor communication, or in other words, poor employee relations, fosters unionization. So why else do workers unionize? Modern Survey conducted a study that measured items such as employee interest in being represented by union, confidence in senior management, and employee engagement. It concluded that 50% of actively disengaged employees would vote yes to unionization, while only 20% of such employees would vote no for union. It concluded that paying attention to employee engagement levels within an organization helps foster positive relations between employees and management and decreases the likelihood that the workforce will look to form a union. Gallup surveys supplement these conclusions. For example, among the over 500 organizations in which Gallup measures employee engagement, 45% of non-union employees were engaged, while fewer than 38% of unionized employees were engaged. So we can generalize by saying that unions have two sets of aims: for union security and for improved wages, hours, working conditions, and benefits for their members. Union security, first and foremost, probably for the security of the union itself. They fight hard for the right to represent the firm's workers and to be the exclusive bargaining agent for all employees in the unit. There are different types of union security: closed shop, union shop, agency shop, preferential shop, maintenance, and membership arrangement. And honestly, I don't understand all of those to be able to go over them in detail with you. But it comes down to improved wages, hours, and benefits is what they're fighting for. The American Federation of Labor and Congress of Industrial Organizations, FLL-CIO, is a voluntary federation of about 57 national and international labor unions in the United States. For many people in the US, the AFL-CIO is still synonymous with the word union. There are 3 layers in this union and most other US unions. The workers join the local union to which he or she pays dues. The local is in turn a single chapter in the national union. The union layer is the national federation, in this case, the AFL-CIO. The Service Employee International Union is a federation of more than 2.2 million members. It includes the largest healthcare union with more than 1.1 million members, including nurses, LPNs, and doctors, and the second largest public employees union with more than 1 million employee or 1 million local and state government workers. Union federation membership is in flux. Some years ago, the SEIU, the International Brotherhood of Teamsters and Unite Here, left the AFL-CIO and established their own federation called the Change to Win Coalition. Together, the departing unions represented over a quarter of the AFL-CIO's membership and budget. More recently, Unite Here left Change to Win and rejoined AFL-CIO. So there's movement, there's discontent, there's a lot of people trying to find the best fit for their organizations. Now we're going to examine 5 examples of unfair union practices and of unfair employer practices in labor laws. So the history of the American labor movement is one of expansion and contraction in response to public policy changes. Until about 1930, there were no special labor laws. Employers were not required to engage in collective bargaining with employees and were virtually unrestrained in their behavior toward unions. The use of spies and firing of union agitators was widespread. Yellow dog contracts whereby management could require non-union memberships as a condition for employment were widely enforced. This situation lasted until the Great Depression around 1930. Since then, in response to changing public attitudes and economic conditions, labor law has gone through three clear periods: from strong encouragement of unions to modified encouragement, coupled with re-regulation, and finally, no detailed regulation of internal union affairs. So the Norris-LaGuardia Act of 1932 set the stage for a new era in which union activity was encouraged. It guaranteed to each employee the right to bargain collective free from interference, restraint, or coercion. It declared yellow dog contracts unenforceable, and it limited the court's abilities to issue injunctions or stop orders for activities such as peaceful picketing and payment of strike benefits. Yet this act did little to restrain employers from fighting labor organizations. So in 1935, Congress passed the National Labor Relations, or Wagner Act, to add teeth to Norris-LaGuardia. It did this by, one, banning certain unfair labor practices, and two, providing for secret ballot election and majority rule for determining whether a firm's employees would unionize, and three, creating the National Labor Relations Board to enforce these two provisions. So that's the NLRB. The Wagner Act deems statutory wrongs, but not crimes, 5 unfair labor practices used by employers. So, interfere with right of self-organization, dominate formation, administration of unions, discriminate against employees for union activities, discriminate against employees for filing unfair practice charges, and refuse to bargain collectively. So the Taft-Hartley, or Labor Management Relations Act of 1947 reflected the public's less enthusiastic attitude towards unions. It amended the National Labor Relations, or Wagner Act, by limiting unions in 4 ways. 1, it prohibited unfair union labor practices. It enumerated the rights of the employee as a union member. It enumerated the rights of employers, and allowed the President of the United States to bar temporarily national emergency strikes. So what this means is that if the police go on strike, the US government can force them to go back to work. If the schools go on strike and the government deems it dangerous for the children to be at home, they can be forced to go back to school or lose their jobs, things like that. So the unfair union labor practices first, it banned unions from restraining or coercing employees from exercising their guaranteed bargaining rights. 2, it is also an unfair labor practice for a union to cause an employer to discriminate in any way against an employee so as to encourage or discourage his or her union membership. 3, it is unfair labor practice for a union to refuse to bargain in good faith with the employer about wages, hours, or other employment conditions. 4, it is an unfair labor practice for a union to engage in feather bedding, requiring an employer to pay an employee for services not performed. The rights of employees and employers. Employees, unions may not restrain or coerce employees. And then the rights of employers must avoid threats, promises, coercion, and indirect interference with workers. No threats of reprisal or promise of benefits. And we have the national emergency strikes. So it allows the president, the US president, to interfere in national strikes. Period of detailed regulations of internal union affairs. So in the 1950 Senate investigations revealed unsavory practices on the part of some unions, and the result was the Landrum-Griffin Act, officially the Labor Management Reporting and Disclosure Act of 1959. An overriding claim of this act was to protect union members from possible union wrongdoing. Like Taft-Hartley, it also amended the National Labor Relations or Wagner Act. First, the act contained a Bill of Rights for union members. It provided for certain rights in the nomination of candidates for union office. It also affirmed a member's right to sue his or her union and to ensure that the union cannot fine or suspend a member without due process. This act could also lay out the rules regarding union elections. So it also made a bigger list of unlawful employer actions. So now we're going to take a look at examples of what a supervisor should or should not do during the union drive and elections. So it is through the union drive and elections that a union tries to be recognized to represent employees. To protect themselves and their employers, supervisors need to understand this process. It has 5 basic steps. 1, initial contact. During the initial contact stage, the union determines the employee's interest in organizing and establishes an organizing committee. The initiative for the first contact between the employees and the union may come from the employees from a union already representing other employees of the firm, or from another union. In any way, it can't, there is an initial contact. In practice, there would be much informal organizing going on at the workplace as employees debate organizing. Both management and unions typically use labor relations consultants. These could be law firms, researchers, psychologists, labor relations specialists, or public relations firms. For the employer, the consulting services may range from ensuring that the firms properly fills out routine labor relations forms to managing the union campaign. So this is a sample authorization card authorizing the the company, the employees, to have a union at the company. So then step 3, hold a hearing. Once the union collects the authorization cards, one of 3 things can occur. If the employer chooses not to contest the union recognition at all, then the parties need no hearing and a special consent election is held. If the employer chooses not to contest the union's right to an election and or the scope of the bargaining unit and or which employees are eligible to vote in the election, no hearing is needed and the parties can stipulate an election. If the employer does wish to contest the union's right, it can insist on the hearing to determine those issues. Most companies do contest the union's right to represent their employees, claiming that a significant number doesn't really want the union. It is at this point that the NLRB gets involved. The union requires usually contacts the NLRB, which represents a hearing, etc. The hearing addresses several issues. First, does the record indicate there is enough evidence to hold an election? Second, it examines the examiner decides what the bargaining unit is, the group of employees that the union will be authorized to represent and bargaining for collectively. If the entire organization is the bargaining unit, the union will represent all non-supervisory, non-managerial, non-confidential employees, regardless of the type of job they have. Then step 4, during the campaign that precedes the election, union and employer appeal to employees for their votes. So here is a sample ballot. How do you lose an election? Unions have won about 69% of the elections held each year. So according to expert Matthew Goldfellow, there is no sure way employers can win elections, but several sure ways to lose one. So reason 1, asleep at the switch. In other words, 68% of companies that lost the union, executives were caught unaware. Reason 2, appointing a committee. Of the losing companies, 36 formed a committee to manage the campaign. The problems are, number 1, promptness is essential in an election situation. Most committee members are NLRB neophytes. Number 3, committee decision is usually a compromise decision. Reason 3, concentration on money and benefits. If you're not looking broadly, chances are it's going to be too narrow. And reason 4, delegating too much to divisions. So for companies with plants scattered around the country, unionizing, one plant tends to lead to unionizing others. The solution is don't abdicate all personnel and industrial relation decisions to plant managers. Dealing effectively with unions, monitoring employees' attitudes, reacting properly when the union appears, and so on, requires centralized guidelines from the main office and its human resources staff. What to expect the union to do with with winning an election. So this is data analyzed from 261 NLRB elections. And basically they will want to use this to boost their chances to win. So reliance on a slow underground person-to-person campaign, building active rank and file participation, press for a first contract early, use inside and outside pressure for tactics to build workers, and their commitment and emphasis on issues such as respect and fairness. The supervisor's role is, number one, don't threaten, interrogate, make promises, or spy on employees. And you may give employees facts, express your opinion about unions, and explain factually correct rules about unions and your experience with unions. Decertification elections, or ousting the union. So there is a legal process to terminate a union's right to represent. It can be very messy. You need to get the law on your side and cross your T's, dot your I's, and decertification campaigns are similar to certification campaigns. There have been about 180 such decertification elections, all in 1 year. So like I said, there's an ebb and flow to the popularity, and when we're right now in this decline, lack of interest, so there are fewer unions right now. That's not to say that it won't increase again in the future. So examples of bargaining that is not in good faith. So what is collective bargaining? Is both management and labor are required by law to negotiate wages, hours, terms and conditions of employment in good faith. So what is good faith? Reasonable effort to arrive at an agreement. And the negotiating team both union and management send negotiating teams to the bargaining table, and both go into the bargaining table having done their homework, understanding the full situation. So it is important that you cost the union's demands carefully, that you take a careful look at both sides and what it will cost you to comply with the demands and get the contracts signed and happy employees versus turning them down and the cost of unhappy employees. Then bargaining and items, labor law sets out categories of specific items that are subject to bargaining. These are mandatory, voluntary, and illegal. So mandatory bargaining items are items in collective bargaining that a party must bargain over, such as pay. Voluntary or permissible bargaining items are neither mandatory nor illegal. They become a part of negotiations only through the joint agreement of both management and union. And then illegal bargaining items are items in collective bargaining that are forbidden by law. For example, a clause agreeing to hire a union member exclusively would be illegal in a right to work state. So bargaining guidelines set clear objectives, understand on what grounds the objectives are established, do not hurry, find out why the other party says and does what it says, and be a good listener. So in collective bargaining, an impasse is a stalemate, and it occurs when the parties are not able to move further towards the settlement. It usually occurs because one party is demanding more than the other party will offer. Sometimes a third party or a mediator can resolve the issue. If the impasse is not resolved, the union may call a work stoppage or a strike. Third party involvement. If you are in those impasses, you could ask for a negotiator, and you have mediators. So this would be a neutral third party trying to assist the principals in the agreement. You could have a national emergency dispute. You could have a fact finder. This would be a national party who studies the issues and makes a public recommendation. You could have a presidential emergency where the president gets involved in that. You can have arbitration, which basically you end up with a binding decision by the arbitrator. And arbitrators are usually lawyers. Mediators and fact finders do not have to be lawyers. And maybe arbitrators don't necessarily have to be lawyers either, but most of them are. And they do have an American Arbitration Association. So the contract agreement must be a 20 to 30 page document or longer. It may contain just general declarations of policy, or it may have detailed rules and procedures. And the tendency today is toward the longer contract. Now let's talk about developing grievance procedures. So when we're dealing with disputes and grievances, you're signing the labor agreement is not the last step in collective bargaining. No labor contract can cover all contingencies. So the grievance process is the process or the steps that an employer and a union agree to follow when there is a violation or a disagreement. So it's the vehicle that you use to go down the path of administering the contract day to day. So this will have a section on what are the sources of grievance and where would they come from and how would they be evaluated. You would have grievance procedures. So how do we evaluate these and how do we move them through steps, okay, to resolve? What would be the guidelines for handling the grievances? And cooperative labor relations. Union membership has gradually declined in America from about 20% of the workforce in 1983, when 17.8 million workers belonged to the union, to about 11%, just over 14 million workers recently. So several factors contributed to the decline. Unions traditionally appealed mostly to blue-collar workers, and the proportion of blue-collar jobs has been decreasing Globalization increased competition and pressures on employers to cut costs, squeezing the unions. And so what are unions doing about this? Of course, they're not sitting idly. The Change to Win Coalition, which represents about 5.5 million workers, is working through innovative campaigns in the private sector economy to ensure that every working person has a living wage, benefits to support their family, and dignity in retirement. Recent trends in the labor law. In late 2014, the NLRB published its final rule pertaining what may call quickie union elections, by allowing unions to call elections in as little as 13 days after filing a representation petition. Then in 2017, President Trump appointed a Republican labor law attorney for the vacancy on the NLRB. Experts assume the board will now move to reverse some of its Obama era decisions, and I didn't keep track of what happened there. Cooperative labor management relations, or many labor management agreements, have included so-called cooperative agreements. And so there you go. Other countries have much bigger union. If you look at the country of France, for example, France is heavily unionized. And then there's countries where there are hardly any unions whatsoever. So country by country, you will see a lot of variations, and you will see a lot of differences in attitudes towards unions as well.